Thank you, Chairman, and will do. My name is Chrissy Buteas. I am Chief Government Officer for the New Jersey Business and Industry Association. Our member companies represent over 1 million jobs in the state of New Jersey. I am joined by my colleague, Ray Cantor. I do want to thank the chairman and members of the committee for the opportunity to testify today, and also to acknowledge the work of the sponsor on issues critical to ensuring workplace safety and equality, something she's championed for her entire career. Unfortunately, we do believe that this bill is not the solution, and are seeking to have the bill held here today. First, on behalf of the employer community, we would never condone or accept any type of sexual harassment or any harassment in the workplace. In fact, NJBIA provides a tremendous amount of information and resources to make sure our members are educated about how to protect our employees and the employers. With that being said, we do have, as I mentioned, significant concerns, and I want to turn it over to my colleague Ray Cantor to highlight what those major issues are, and look forward to having the opportunity to continue to work with the sponsor on this legislation.
Thank you, Mr. Chairman, members of the committee. Again, my name is Ray Cantor. We generally agree that there is a need to make sure that workplaces are safe and that sexual harassment and discrimination are eliminated to the extent possible in our workplaces. However, as drafted, we believe that this legislation will actually create a more hostile environment in workplaces, where employees are afraid to interact with each other, where customers all become potential litigants, and where the HR department will govern every aspect of interactions within our businesses. I want to focus on three parts of this legislation that we think are the most egregious. One, the elimination of the severe or pervasive standard for bringing a suit, the elimination of employer defenses to litigation, and the elimination of the responsible or the reasonable person standard to judge a person's conduct. On the severe or pervasive standard, that standard has been in place since the state Supreme Court decided in 1993 in the Lehman versus Toys R Us litigation. That case decided that the conduct in order to prove a case for sexual harassment under the law against discrimination must have been sufficiently severe or pervasive so as to alter the conditions of employment and create a hostile work environment. And the reason the court created such a standard is because they feared that if they did not, then every little interaction that happens in a workplace would be the basis of litigation. The severe or pervasive standard was set in order to avoid situations where just personality conflicts, a lack of sensitivity, or mere offensiveness became a basis for bringing a lawsuit. In a recent case, Godfrey versus Princeton Seminary, the Supreme Court went even further in explaining why the severe or pervasive standard was necessary to keep in the law. They want to avoid situations where a hypersensitive employee who might have have an idiosyncratic response to conduct that is not objectively viewed as harassing. We're trying to avoid where just sensitive people are taking things the wrong way, where normal interactions become parts of litigation, where someone's awkward statement or unintended action may be the basis of litigation. If we eliminate the severe or pervasive standard that has been in our jurisprudence for the last 25 years, we're setting up a situation where everything could be possibly the basis of litigation. As was mentioned earlier, all this bill does, or what this bill does, is say the only defense and replacement of the severe or pervasive standard is that the offense cannot be merely, quote, petty slights or trivial inconveniences. Petty slights or trivial inconveniences. Anything above that is potentially a source of litigation. Most problematic of this bill is that it also eliminates all employer defenses. Currently, under the law right now, an employer can have as a defense the fact that they had policies put in place. They had training for their employees. They took prompt action once they became aware of a violation. All those defenses have now been removed from the law, or would be removed from the law if this legislation were to pass, basically making sexual harassment a strict liability offense with a standard that no one even knows what it is. So again, it becomes a situation where an employer has no ability to take action before or after knowledge to be able to avoid this type of litigation. The third part I want to mention as well is the reasonable person standard, and this gets back to the severe or pervasive, rationale of the New Jersey Supreme Court. Historically, in jurisprudence, when you look at someone's conduct and how someone would react to it, you look to see whether or not the reaction would be that of a reasonable person. This bill would remove that standard and make even the very sensitive, the hypersensitive person who the courts were fearful of, that it would be that person's subjective view of someone's conduct would be the new standard to determine whether or not there has been harassment. And by the way, the bill also provides that there's not even need to be any harm shown to that plaintiff in order to bring a case. So what we have here is the removal of the safeguards of severe pervasive to make sure that these are significant violations and not just things above a trivial or inconvenience. We have the removal of employer defenses. We have the elimination of a reasonable person standard in order to weigh and judge whether or not someone's reactions were reasonable. You put that all together, and I'll disagree with someone who had talked before, this will open up the floodgates for litigation. Everything that could possibly happen in a workplace, your workplace, between customers, between independent contractors, everything now becomes a source for potential litigation. We would ask this committee to hold this bill today, and it needs more work. Thank you.
Thank you, Mr. Cantor.